Okay, welcome to our guests. Thank you. Silakan, selamat pagi teman-teman. Silakan diisi juga kursi bagian depannya terlebih dahulu. Okay, test. Bismillahirrahmanirrahim. Your Excellencies, Dean of Faculty of Law, Universitas Islam Indonesia, Professor Dr. Budi Agus Riswandi, SHM. The Honorable Vice Dean for Research Management of Faculty of Law, Universitas Islam Indonesia, Dr. Srihastuti Puspitasari, SHMH. The Honorable Vice Dean for Religious, Student, and Alumni Affairs for Faculty of Law, Universitas Islam Indonesia, Associate Professor Agus Triana MH, PhD. The Honorable Head of Undergraduate Study Program in Law Faculty of Universitas Islam Indonesia, Mr. Dodik Setiawan Nurherianto, SHMH, LLM, PhD. The Honorable Secretary of International Undergraduate Study Program in Law, Faculty of Law, Universitas Islam Indonesia, Dr. Aruna Elmina Marta, SHMH. The Honorable Secretary of Undergraduate Study Program in Law, Mr. Bagya Agung Prabowo, SHMHUM, PhD. All the leaders of clusters in Faculty of Law, heads of divisions in Faculty of Law. The Honorable Speakers, Mr. Christopher Michael Kason, GD LLM, Associate Professor Dr. Jadi Zaidi bin Hasim, the Honorable Dr. Christina Fixer, PhD, the Honorable Dr. Muhammad Halmi, MD, the Honorable Miss Siti Rohama Mardatillah, SHMH, the Honorable Moderator, Ms. Siti Rahmana Fikasari, SHMH, and all the audiences. Assalamualaikum warahmatullahi wabarakatuh. Good morning and a very great warmth to each and every one of you Welcome to International Student Colloquium 2023 under the title Climate Change and the Rule of Law. I am Siti Inaya as the Master of Ceremony in this event. On behalf of our organizing committee, we extend our appreciation of you for taking the time to attend this event. Well, ladies and gentlemen, before we start this seminar, let me read the agenda for International Student Colloquium 2023. The first agenda is reciting the Holy Quran by Taki Zakiuddin, bringing Quran Surah Al-Mujadalah verse 11 as a student of Law Faculty batch 2022. And the second agenda, sing Indonesian National Anthem and Hymn of Universitas Islam Indonesia. The third agenda is opening speech by the Dean of Law Faculty, Universitas Islam Indonesia. The fourth is Summon Dance performance by Safira. And the fifth is the main agenda. The sixth, Q&A sessions, and the last one is closing. So, ladies and gentlemen, to ensure the seminar run well, please make sure your phone is in the silent mode or switched off. And we also request to our attendees to refrain from any conversations during the seminar, so it would not distracting for other participants. And the last one, we encourage you all to participate in these discussions and ask questions related to the seminar during the Q&A sessions. So without further ado, let's start our first agenda by reciting the Holy Quran. Please welcome Taki Zakiuddin with Surah Al-Mujadalah verse 11. The stage is yours.
Assalamualaikum warahmatullahi wabarakatuh. A'udzu billahi minasy syaithanir rajim. Bismillahirrahmanirrahim. Ya ayyuhallazina amanu idza qila lakum tafassahu fil majalis إذا قيل لكم تفسحوا في المجالس فافسحوا يفسح الله لكم وإذا قيل انشزوا فانشزوا يرفع يرفع الله الذين آمنوا منكم والذين أوتوا العلم درجات والله بما تعملون خبير صدق الله العظيم والسلام عليكم ورحمة الله وبركاته.
Thank you, Mr. Taki Zakiuddin, for bringing the beautiful verse. And moving to the second agenda, sing the Indonesian national anthem and hymn of Universitas Islam Indonesia. The audience is asked to stand. The audience is pleased to sit down again. Okay, ladies and gentlemen, the next agenda is opening remark by the Dean of Law Faculty, Universitas Islam Indonesia. Please welcome Profesor Dr. Budi Agus Diswandi, SH M.Hum. Please give your round of applause.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin, wassalatu wassalamu ala asrofil anbiya'i wal mursalin wa ala alihi wa sahbihi ajmain. Amma ba'd. The honorable leaders in Faculty of Law and also lecturer in Faculty of Law, speaker, and ladies and gentlemen, first of all, welcome to Faculty of Law, Universitas Islam Indonesia, and thank you so much for attending and joining with this program. Today, we will hold on International Student Colloquium on Climate Change and Rule of Laws. From this program, we invite speaker from Vietnam, and then Hungary and Malaysia, and also from our faculty in Indonesia. We hope this program will increasing our knowledge and we can sharing information about rule of law and climate change. Finally, enjoy with this program. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor Budi, for the nice greetings. And before we move to the main agenda, there will be a performance, summon dance performance from Safira. So please pay your full attention. Please welcome Safira. Give your round of applause, please.
Cik. Assalamualaikum warahmatullahi wabarakatuh. Allahu Allah, 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 Allah ya Rabbi. Kita mau demi sejahtera doa. Jaro dua belah atu jemalah. Jaro lon siplo di atu ulai. Meah lelaki bawa redumlah. Jangan Hai jak kena haide tajak medike taduk besar betul pada banjar saduane bila besar ada medike hai seni budaya bak jaman jino haide jaman kaake Kutangan digledik ke kurengena budaya Islam saya harap relay budaya kape hai rame ang hawa budaya Islam saya harap relay budaya kape rame ang hawa Amin Allah Summa amin Urang mukmin berkat rahmat Allah yang beri nangro ajai makmu sejahtera berkat rahmat Allah yang beri nangro ajai makmu sejahtera ini janda kuning bisa tempat janda di kamu salah putih dengan janggut hai janggut kuning dengan bisa tempat janda di kamu salah Hai bungong jumpa megah di Aceh bungong dulu beh indah lagoina hey bungong jumpa megah di Aceh si ulah indah mati ada bermepan jerah kata ada bermepan kita ingat-ingat wahai leratan kebudayaan berkata jaga dari sedar kira Pak Isaman Bandung antaranya tradisi bangsa si jumpa mira si ulah kehendak anau Dilaut aroma pulau berahu dua-dua hirakan belela no budaya no buta jaga Ya Allah siwa ponang lo kulit di putih di padi sini di Aceh Raya dalam sejarah kaluh metulis lepaskan hari Iskandar muda Olah hoya Rakan Kita toprak Olah hoya sayang rakan Bandung besar bersama Aceh mereka sesaudara Langit-langit menyala minta si goreng ayam baru Nabi Tala Tajak ubanda dua pan mutun pertama birun dua pedada kalau lentanyang bak rata urung elak lat bakeng sepo sidara Hoka Raja Lun Putra Nepio Bagang Pungnya Hoka Raja Lun Putra Nepio Bagang Pungnya Assalamualaikum warahmatullahi wabarakatuh.
Wow, a really beautiful performance from Safira. Once again, give your best applause for Safira. Okay, for your information, ladies and gentlemen, Saman dance is a traditional dance from Aceh, Indonesia. And long-awaited event, ladies and gentlemen, we have a really exciting panel speakers for today that will be guided by our beautiful moderators, Miss Siti Rahmanovikasari SHMH. But before I place the whole stage to her, I hope that you will find the presentations and discussions informative and engaging. So sit back, relax, and enjoy the seminar. And to Miss Siti Rahmanovikasari, SHMH, the whole stage is yours. And Assalamualaikum warahmatullahi wabarakatuh. Okay, along with wait preparations, ladies and gentlemen, once again, to ensure this seminar will run well, please make sure that your phone and or silent mode or switched off. And we also hope our audience is different side from any conversation, so it will not disrupt our other participants. Thank you.
So thank you very much for the Master of Ceremony. Okay, I think we're ready for starting the discussion today. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. Let me first address my salutation and also greeting to Honorable Dean, Faculty of Law, Universitas Islam Indonesia, Bapak Profesor Dr. Budi Agus Riswandi, SHM our Vice Deans of Faculty of Law, Universitas Islam Indonesia, Ibu Dr. Sri Hastuti Puspitasari, SHMH, and also Bapak Dr. Andes Agus Trianta, MA, PhD. The Honorable Head of Department Faculty of Law, Universitas Islam Indonesia, we have Bapak Dr. Mahrus Ali, SHMH. Also the Head of Undergraduate Program in Law, Bapak Dodi Setiawan Nur Herianto, SHMH, LLM, PhD. Good morning, Pak Dodi. And his secretaries, we have Bapak Bagia Agung Prabowo, SH, MHum, PhD, Pak Bagia, and also Ibu Dr. Aroma Elmina Marta, SHMH. Let me also extend my warm welcome to all distinguished speakers here. We have Mr. Christopher Casson, GD LLM, Pak Chris, good morning. Also we have Dr. Christina Fixer, PhD, Bu Christina Fixer. Also we have Ibu Huang Zung Nguyen, LLB LLM. We have also Bapak Associate Professor Dr. Jadi Zaidi bin Hasim, good morning, Assalamualaikum. And joining with us using Zoom meeting, Ibu Siti Ruhama Mardatila, SHMH, and also all the participants, our students that I'm very, very proud of. Ladies and gentlemen, my name is Siti Rahmanovikasari. It's my honor today to become the moderator for today's agenda. This is the International Student Colloquium 2023. Hosted by Faculty of Law, Universitas Islam Indonesia, with our topic today is climate change and the rule of law. I will give you a brief of topics and issue about this today's topic, ladies and gentlemen. The issues about the climate change rose post-industrial revolution and continue with the establishment of Intergovernmental Panel of Climate Change, or we call it as IPCC, in 1988. And then the climate change itself as a global issue at the moment has prompted the issuance of various conventions and also the protocols, right? Such as UNFCCC, United Nations Convention on Climate Change, in the Rio Convention, and then continue with the Kyoto Protocols and also the Paris Agreement itself. As the climate change seen as serious matters because it have a broader impact to environments, to health. Also, in the latest discussion and also research, the climate change also gave impact to the food security itself. So all the countries around the world need to conduct or issuance the regulation at national level. And also beside the regulation and also instrument to mitigate and to manage the climate change. Also, they have we call it as National Determined Contribution, right? Our NDC's commitment for decarbonization program globally. And as the COP26 in Glasgow last year, I think, was accelerate the net zero emission achievement to 2050, and this is a very huge homework to all countries around the world. So all the countries all around the world need to implement their climate change mitigation regulation alongside with the any measurement to exercise the legal enforcement itself. So ladies and gentlemen, to more deeply discuss about the this issue, first I will introduce you to all excellent panelists. But before that, let me invite all the speakers to come forward. Please, Mr. Christophers, and then Ibu Dr. Christina Fixer, and then Ms. Pong Zung Nguyen, and then Bapak Associate Professor Dr. Jadi Zaidi bin Hasim to come forward. Please give big applause to them. Yeah. Okay. Maybe. Okay. Ooh. Two men and women beside me, in my right and my left. Equal, it's equal, yeah. Okay, ladies and gentlemen, let me read brief of your curriculum vitae, so our participant here can very understand and know more about you. First, we have in my very right side, we have Bapak Christopher M. Kesson, GD LLM. Everyone knows about Pak Chris, actually, but I still need to read his CV. He's got his Bachelor of Art from Washington State University, Doctor of Jurisprudence from Seattle University School of Law, and LLM from University of Miami School of Law, right, Pak Chris, yeah? At the moment, he is also as lecturer at Faculty of Law UII, specifically in Department of International Law. And he's also as the visiting lecturer at Gangwon University, South Korea, Professor Emeritus at University of Washington, US. Besides that, Pak Chris also as a litigation attorney and Assistant General Counsel, one of which in Amazon.com. And became the international legal consultant and having, of course, the numerous publication in international law, public international law, especially. Thank you. Please give applause for Pak Chris. Yeah. And then right beside me, we have Dr. Christina Fixer, PhD. She is from Hungary as the Assistant Professor of Law in Faculty of Law, University of Debrecen, Hungary. Yeah, she got her PhD diploma also from Debrecen University, right? Yeah. Her expertise is in legal philosophy and European Union law. Yeah. She has excellent publication. Also became the panelist in several conferences at European countries. Give applause to her, please. Okay. In my life, we have Mrs. Pong Zung Nguyen LLB LLM. Yeah, she has lectured at RMIT University, Vietnam. She has undergraduate degree from Hanoi Law University and master degree from Newcastle Law School. She is expert in public international law, right? Yeah, and has a lot of publication, journals, and books. And your latest publication in the book chapter, right, about the climate change itself. And in my very left side, we have Associate Professor Dr. Jadi Zaidi bin Hasim. He is from Malaysia, our neighbor. Yeah, Dr. Jadi Zaidi Hasim is the Dean and Associate Professor at the National University of Malaysia, or UKM. Universitas Kebangsaan Malaysia. His expertise are sport law, land law, and administrative law, and he's appointed as legal committee for the Football Association of Malaysia and committee member in National Dispute Resolution Chamber, right, Pak Jadi? He's also a certified mediator in the Malaysian Mediation Center, has published many articles and books related to land law and sport law. Please give applause to four speakers who arrived in this Faculty of Law. And we also have one more speaker who joining us via Zoom meeting. I think you already know Ibu Siti Ruhama Mardotilah SHMH. She is our lecturer, also in Faculty of Law UII. She obtained her bachelor and master degree from UGM, Faculty of Law. And at the moment she takes PhD at the Groningen University. Her expertise is in environmental law. It's shown by a lot of publication he wrote about environmental law, so do her dissertation in climate change litigation. Okay, we all know about the excellent speakers for today's issue. So, ladies and gentlemen, before that, let me read about the some aspect. Yeah, first, that the speaker will present the material about 20 minutes. We have 20 minutes, yeah. And then following that, we will have a Q&A session, and then we'll be closed by the conclusion. So, ladies and gentlemen, without any further ado, we have our very first speaker. He is Mr. Christopher M. Casson, GD-LLM, who will deliver his material about energy transition and the United States climate legal policy. Please give applause to Pak Chris. You have 20 minutes. Pak Chris, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. First of all, I'd like to thank Pak Dekan and the UII, as well as the rest of the leadership for, I won't say inviting me here, I'll say inviting me to speak today, along with my esteemed speakers. I'd also like to thank many of my students and some of my newer students who are joining us, either by force or by request. So this morning, I'm going to talk about a little bit about what's happening in the United States. And I'd love to thank the committee for organizing this. However, I feel like I'm in a bad place because I had to follow the Saman dance. And it's much more exciting than talking about climate change and litigation in America. But I think the issue that I'll be talking about will apply not just to the United States, but hopefully to your own countries as well. So I'll just briefly give an introduction and talk about how we address climate change, how it's changing in America. And a little bit about the political barriers to effectively address climate change in America. Then I want to kind of switch gears and talk about a recent case that has been litigated in the United States, which gives us a little hope that we can overcome some of these political, economic barriers and actually see some effective climate change. And again, I'll briefly talk about sort of where I see the international, how internationally we're addressing climate change, and a little bit about Indonesia, but I'll be brief on that because that's not my expertise. So here is what I'll call a positive trend of renewable energy in the United States. And you can see fossil fuels are, of course, the highest used form of energy. Followed a distant second now, by 2018, a distant second by renewables. And I'll say renewables meaning wind energy, geothermal energy, and solar energy. And then the good news is that the fossil fuels are steadily being reduced, along with nuclear power steadily being reduced. But as you can see, we're a long way off. So you can see that's not just it's to scale to see how far we are away from truly embracing renewable energy. The way we motivate in America for action to be taken is we call them tax incentives. And I don't want to bore you even more with tax law this morning. No offense to those of you who major in tax law. But we offer tax deductions. We deduct an amount from our taxable income. Or we offer tax credits. And especially for corporations, to motivate them to look and embrace alternative energy rather than fossil fuels. We give them a tax break. We don't necessarily subsidize. We don't give money from the government, but we let companies keep more of their money. Basic is how we motivate this. And recently, we passed a law called the Inflation Reduction Act, which sounds like it has nothing to do with renewable energy. But a key portion of this Inflation Reduction Act, and it was just passed this year, is it gives tax credits or tax incentives for investments in renewable energy. So again, we can't stop fossil fuels from being burned. We can't make them illegal in a sense. But we motivate through taxes. That's kind of our system in the United States. Again, one thing you need to understand about the United States is we don't just have one constitution. So we have the Constitution for the entire country, but we also have a separate Constitution for each state of the Union. So effectively, we have 51 constitutions, depending on where you are. The federal Constitution, of course, applies to everybody in America, and each state has its own Constitution which applies to the citizens of the state, the residents of the state. And there aren't many rules other than a state constitution can give more rights to its citizens, but it can't take away rights from the federal Constitution. And this is going to be important in our case. So, for example, one state can give greater rights to environmental protection, but that same state can't take away freedom of religion, for example. And so it becomes a bit complicated when we're talking about constitutional law, etc., in the United States. And a little bit about our constitutions and a little bit about the politics. If you look at the map of the United States, you'll notice we have blue states and red states. And we generally consider these, the blue states are sort of on the left, more liberal, and the red states are on the right, more conservative. And you'll notice from the Constitution and the environmental regulations, there's much greater effort in the blue states to address climate change as opposed to the red states. And that's a matter of politics. Often, politicians like to appeal with people who have a lot of money. It's not just America, obviously, where this happens. But they want to get elected, especially in these red states. They have to appeal to people who have a lot of money. And in these red states, many of the people who got rich off of pulling stuff out of the ground and selling it, meaning fossil fuels and other non-renewable resources. And so, if we have this political backdrop, we have the necessity of an independent judiciary. So the executive branch, the president of the United States and the governor of each state, the legislative branch, those are all elected officials. And the court is sort of charged with checking and balancing against the majority of a particular country or a particular state. Again, we don't have a constitutional court in America. We only have one Supreme Court. Well, you have a Supreme Court of each state, and then we have the Supreme Court of the United States. And they have to, of course, they're a court of appeals, and they also are charged with upholding the Constitution. And then, of course, there are the inferior courts in each state and the inferior courts in the federal judiciary. But explaining all of that could take hours, so I'll move on to what I think is a unique case. And it's called Held versus State of Montana. And quickly, in 2020, this group of teams, and if you can see the picture, those are the plaintiffs in Held versus State of Montana. It's Held et al. Versus the State of Montana. So this was a group of students who filed suit against the State of Montana. They basically said that the state was not protecting their constitutional rights. They attempted to have the case dismissed. Don't worry too much about the procedural history. But in August 14, 2023, the court, the judge, ruled in favor of the plaintiffs and said that the state, by changing its law, was violating the Constitution. Now, in our American Constitution, the U.S. Constitution doesn't say anything about a clean environment. Not in any of the original Constitution or any of the amendments. However, the state of Montana, that's the courthouse, old picture, I think. The state of Montana has these provisions. The state and each person shall maintain and improve a clean and healthful environment in Montana for present and key phrase future generations. Article 9. Also says that all persons are born free and have inalienable rights. This includes a right to a clean and healthful environment. And the law that violated this was a provision that said the state of energy policy, which basically favors fossil fuel extraction and sale. Montana has huge amounts of coal in its mountains. They made a climate change exception which basically said in granting a permit for a new energy facility or a new mine, a new drilling operation, you cannot consider climate change. And the students said that's terrible because it violates our constitutional right to a clean environment. And they won. They won at the initial trial. It was a 2-week trial. And they prevailed. Now, of course, the judge found that MIPA, this law, said that it truly violates the state's constitution and effectively struck down the law. So because of the independent judiciary, they were able to say this law that violates the Constitution is no longer a law and can no longer be enforced. And that comes to this issue of standing. And standing, especially in environmental law, is crucial. And this is one of the things they thought about. They said, these are kids. They don't have standing to bring a lawsuit. Okay, they have to have a protectable right. But the court decided that this Constitution gave them that right. And who has the right to protect the environment? Who has the right to sue to protect the environment? That's some of our good news. And there's good news around the world. But mostly these kinds of cases have been unsuccessful. There's been hundreds of other cases in the United States that haven't been successful. We talked about, I heard mention of the Paris Climate Agreement. And they had a lower court had ruled in favor environmentally that a third runway at Heathrow Airport violated their international obligations under the Paris Climate Agreement. But the Supreme Court overturned that ruling, basically saying the Paris Climate Agreement is not international law and is not domestic law. It's non-binding. More good news? And this was a unique case I found. In Pakistan. And in Pakistan, a group of women filed a constitutional claim. And they relied on the public trust doctrine. And I know I have at least one of my Pakistani students here today, that they actually can use U.S. law as precedent in deciding cases. And so they applied this case, and again, a favorable ruling that said taking inaction to have pollution violated the Constitution, violated their rights. International action, recently coming out of the United Nations conference on climate change, basically identified the right to a healthy environment as a human right. Basically adding it to the list of human rights. Which sounds like good news. However, those of you who have taken international law know the difference between a treaty and a declaration. And there were 161 votes in favor. Everybody cheered and they were very happy to see this law and this declaration. However, states were very careful to make sure that everybody knew that none of it was enforceable. That not only was this non-binding, but that there were no enforcement provisions, and that this right is not included in the ICCPR or the ICSCR. And there are some other issues about some technicalities as well. So everybody patted themselves on the back and said, "Good job." But the legal enforceability is still lacking. And so how do we arrive at giving standing and legal enforceability of protecting the environment? Well, there's a new movement now called the rights of nature. giving natural the environment. Two things: giving the environment protective legal status, and also giving any citizen the right to sue, to have standing to sue, to protect their rights. And there's two examples. One is in Panama. They passed legislation giving rights to the natural environment. And this was a case, they're going to build this huge copper mine in Panama. And it affected the sea turtles. So the endangered sea turtle beds where they lay their eggs before they go out to the water was going to be destroyed by this copper mine. And they sued under this law, and were given the standing to sue and prevailed in court. So the Panama courts indicated that people have that sea turtles have rights, and that people can sue to protect them. In a similar case in my hometown of Seattle, Washington, there was a case brought recognizing the rights of salmon. And in that case, it wasn't decided by the court, it eventually settled. But the city of Seattle said the rights of salmon are protected, and that Indian tribe has the standing to sue for those rights. And they ordered the reconstruction of hydroelectric dams to allow this salmon to swim up and down the stream as they do. So there are encouraging signs, but we're still far away. Closer to home, I won't bore you with this. I'll just go through this really quickly. These are some of the provisions that could give rise to legal action, to litigation in Indonesia. Here's just an example where there was some accountability, holding that states do have to follow the law. And again, another example of an independent judiciary holding the legislature accountable. So essentially, in conclusion, I know my time is running out. I was careful. And again, I say this saying this as an American. And Americans love to sue people. It's almost like a sport in America. In fact, we sue people about sports. So it's sort of a cultural thing to look to litigation to provide this. And so far, we've only taken baby steps. We haven't gone very far. And the Montana case, the precedent of that Montana case is limited, first of all, limited to Montana, and not the whole nation or anywhere else in the world. The other important thing is to remember we need an independent judiciary that is accountable only to the Constitution and not to special interests or rich people. It may be in some countries where there is not an independent judiciary that international courts may be effective. And on the last note, that website up there, climatepeacechart.com, is a collection of United States and worldwide cases that are pending or have been concluded regarding that have sued them, basically what we're talking about today. So thank you very much. I look forward to your questions or concerns later on, and I look forward to hearing from my esteemed colleagues as well. So thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh.
Thank you very much, Christopher. I was very pleased to hear your presentation in every seminars, yeah. So we have a lot of insights from Pak Chris, start from how the data about renewable energy in US continues growing, and then a tax incentive. This is one of my concern, Pak Christopher. The tax incentive also can be used as the motivations. It's very good. And legal protection for sustainable energy in US still face some obstacle, I think, because of political aspects, yeah. And the baby step in the litigation, I think it's already became a huge step, yeah, even though it's still a baby, yeah. Based on some judicial ruling about the environmental cases, it strengthened the position of plaintiff to become the legal standing for the environment right itself, and also it strengthened some environmental right as part of our human right itself. Pak Chris, it's very nice presentation. Please give applause for Pak Christopher again. Okay, so ladies and gentlemen and my students here, we're going to have our second speaker. He is Bapak Associate Professor Dr. Jadi Zaidi bin Hasim, who will deliver his materials about land reform and sustainable development. Yeah, in the Malaysian perspective, we have 20 minutes, Dr. Jadi. Without any further ado, the floor is yours.
I thought I'm going to be the last person. All right, thank you very much, Ms. Chairman, the moderator for today. Respected panels for today's sessions, all the lecturers, as well as the most lovely one here, students of Universitas Islam Indonesia, UII. All right. I would like to say thank you very much for inviting me. I believe that what I'm going to tell you today, or what we're going to discuss today, is something more simple. We are talking about land law, but of course in the perspective of Malaysia. I didn't expect that today we're going to talk lots about climate change, because what I'm going to talk about, of course, on SDGs. Everybody knows that when we talk about SDGs, we talk about SDG 2030. Now it's 2023. It's only 7 years left to achieve SDG 2030. I'm not sure whether we are ready or not, but this is the idea of doing this session or seminar. So at least for you understand very well what is the direction what's going to be for SDGs or agenda for SDGs. All right. As you can see here, my topic is very simple: land reform and SDG implementation in Malaysia. If I can briefly explain the topic itself, we are talking about two important elements. The first one, of course, law reform, and the second one, SDG institutions. And of course, I'm not going to tell you about everything on law reform or land reform in Malaysia. I believe what we are doing as lecturers or academicians is to inspire you. So after this, probably, if you're interested to join UKM, for example, or any other institutions around the world, then you can have basic ideas of what the thesis you are going to write. When we talk about reform, you must understand there are two types of reform. The first one is we call it institutional reform, and the second one, of course, legal reform or legal framework reform. What I'm going to tell you today, this morning, is only on legal or legal framework reform, which is very, very substantive in nature. Because when we talk about implementation, when we talk about institutional reform, we are talking about institutions, the organization that carry out the implementation of the institution itself. So, 15 to 20 minutes, probably 10 minutes given to me, I will explain what are those land reforms in Malaysia, right? And number two, in terms of SDG implementation, I believe nothing much we can do. As explained just now, when we talk about the definition of sustainable and sustainable, it seems that Mr. Christopher is correct. Okay, there is no such thing as defining or protecting the implementations of. I will show the draft after this. But at the lower level, at least at the national level, people are doing their task or doing whatever things that they need to do in order to achieve these SDGs. All right. When we start, I'm not sure whether I can play the videos. If you can click this photo, then you can probably. Is it possible to click this video? Okay, there's a link here. I'm not sure whether I can click it. Just to show the implementation of SDG as carried out by the universities, by UII. If not, then it is okay because the video itself probably takes more than 5 minutes. Alright, anyway, go back to the slide. Okay, go back to the slide. Okay, this is the video that I'm talking about that being is there any music? Okay, since there's no music, probably I can explain a little bit. This is what we did this year, ISDRS 2023, which was actually organized by Faculty of Law UKM in order to what we call visualize the idea of SDG 2030 in the context of Malaysian perspective. Of course, we're talking about 5 areas of SDGs, 5 P's we call it. Anyway, you can enjoy the videos. Since there's no music, I'm so sorry about that one. Sure. Okay, there are 10 tracks during the seminar. This is special themes on Asians because never been in Europe talks about Asians. This is our faculty. Those who wish to come to Malaysia and visiting our faculty. Alright, I think we stop here. Otherwise, I think it's right. This is Malaysia. This is not promotion. Alright. Okay, I think we can stop the video. This is the co-host, co-organizers of this event. Probably you can stop the videos. Yeah, as I said, it takes 5 minutes. So half of the presentation will be being visualized to the videos. Okay, go back to the slides. Just now, we are talking about the implementation of SDGs, or the spirit of implementing the SDGs in Malaysia through institutional work. But at the same time, if you can see the performance of elements of SDGs itself can be shown in this next slide. Okay. All right. This is Malaysia. Despite of having what we call a lot of things in order to materialize SDGs in Malaysia, yet we are achieving not 100%, but roughly 66% of it, which is, of course, if you consider past for you studying law, probably you will happy to receive 68. But then to certain people achieving this SDG for the purpose of 5 P's, for the purpose of nations as well as global, then this is not good enough. What more? If you can see here, the numbers of performance since it was introduced in 2015, now it's 2022, not even half. And then which is correct, we addressed this morning, the issue of climate change with red colour. That's why the idea of having this session, this panel, this workshop, we call timely to address these issues. So here we are, Malaysia. So there are many other things that we need to do. But then, in terms of what we call institutional frameworks, those 5 areas are key indicators that need to be addressed with the remaining 7 years. At least, we are talking about equitable economic growth, agriculture, productivity, food security. When we talk about equitable economic growth, we are talking about SDG 1. Number 2, when we talk about the land management, SDG 2. When we talk about environmental sustainability and biodiversity conservation, of course we are talking about SDG 10, urban planning, land on urban cities, we are talking about SDG 11, and climate change that's going to be discussed by the rest of the panelists. So, this is what we wish to achieve through land reform. But to what extent it can be achieved, as shown by the previous slides, it seems that it is still far to go, right? So that's why, in terms of basic targets of law reform, what we will do in Malaysia is to have at least related to 3 important points. The first one, ownership. There are many issues of ownership, I believe, in Indonesia as well. We are talking about fraud. People are being cheated on the land ownership. You believe, this is your land. In fact, the land is not there. Your land is not being registered. This, of course, I'm going to explain further tomorrow, because I have guest lecture to all students who are taking land law probably. And then, number 2, in terms of distribution. We are talking about equal distribution between women and men. Whether men have land or not, or women, should you then possess equal distribution? Because in Malaysia, if you know that the state of Negeri Sembilan, the land ownership normally given to women instead of men, because they believe men are working very hard, they can get their own property later on. But women, they are considered very weak, so-called weak, and need to be given without gift. Alright? And then in terms of use of land itself, we are talking about land management, land planning. There are many issues where land being what we call being managed improperly, in terms of the way the land being used for agriculture, with all toxics, with all kind of things that not very good, that not give healthy land to the people. So roughly, when we talk basic terms, basic targets of land reform in Malaysia, we are talking about these 2 elements. I'm not going to reach to all of you. Okay. Then, the next slide. The rest of the slides is going to discuss about the areas of land reform in Malaysia with regard to the SDGs. As you can see, SDG number 1, we talk about how law reform or land reform can contribute to poverty. Number 2, in terms of zero hunger, we're talking about how we try to sustain land use and agriculture practices. The best practices will give more plants and more healthy vegetables. And number 3, in terms of land reform, that reducing the socio-economic inequalities between men and women just now. And number 4, we talk about law reform in urban areas that contribute to sustainable urbanization, the usage of efficient land for land planning, Because in Malaysia we have Town and Planning Acts that dedicated specifically on how to manage the property in Malaysia. But then managing property in Malaysia and managing environmental base of properties in Malaysia is two different things. Because we need one other requirement to ensure that whatever planning is done by the developers fulfilling all the environment's elements, IA, etc. And number six, I lost count, but I believe number six. SDG 15, when we talk about sustainable land management practices to conserve other parts, animals, carbons, etc. And number 16, when we talk about tenure systems, 16 closely related to peace and justice. We are from law faculty. Normally, when we talk about SDG, number 16 is always going to be our first priority. If you can show the diagram showing what are the activities done by law faculties and SDGs, number 16 will represent the big chunk. Because when we talk about SDGs, we take more about justice instead of other SDGs. This is normal. We cannot blame. Even the university, the UKM, the law faculty, for example, when we try to come up with charts, what are the areas that being discussed or being researched by our students, it seems that the 16 is going to be representing big chunks. Okay? Again, this SDG 16, when we talk about tenure system, we are talking about protection, we are talking about justice on how to protect the court's land by the people. And number 17 is of course on collaboration. Today you can see all panels come from different areas of the world, and we are collaborating talks about climate change. This is the idea. But of course, in terms of collaboration, in terms of SDG 17, we are talking about the authorities, the governments, public sectors that should work together in order to ensure that SDGs can be achieved. Alright? The rest of my slides, of course, I'm not going to explain everything, is on examples of law reform. As I said just now, when we talk about reform, there are legal reform and institutional reform. But it's good, for example, those who are interested to explore more, to know more about land law, or probably land law and SDGs, what kind of law that applicable to Malaysia, you can see through this kind of legislation. For example, we can see SDG 1, there are numbers of law that related to SDG number 1. SDG number 2, we also have a few laws. We have 5 basic laws here that related to SDG number 2. Besides SDGs, number 5, we talked about 3 basic laws that related to SDG. And then number 11, roughly we have 6 SDGs. I believe some of you have in class, right? Yeah, I do understand very well because as a dean of the faculty, during the lectures like this, when we invite them, it's kind of compulsory attending the seminar. So those who have in class, please, your priority is attending the class. It's okay because I think the slide can be distributed or can be taken by the committee, the organizers to all of you. Because the real intention is to explain everything on the slide itself. You can access the slides. But most important, as I said just now, to inspire you, what kind of law that you're going to discuss when you want to do your master level as well as your PhD. Roughly, what I'm giving you this morning through the slides is just numbers of legislations related to law reform, especially on land matters. Again, I continue for the next 3 minutes. We are talking about SDG 15. This is the areas of law that related to SDG 15. And then besides law, legislation, we also have policies. Policies come up with guidelines. Guidelines will direct the government on what they should do. of course, okay, when we look at law normally come up with the penalty. Those who are able to fulfill certain laws will be penalized. That's the whole story. Okay, this is other examples of the policies based on SDG 15, with national forestry policies. And just now, okay, if we really have time, I suppose we can discuss it on SDG 16, because as you can see here, for example, when we talk about national land code, one of the important codes for land in Malaysia, I should discuss it one by one in detail. But since okay, we only have 15 to 20 minutes, we just go through those elements that is incorporated in national land codes and can be discussed in detail or can be researched in more detail in order to what we call fulfill the SDG 16 on land matters. Okay. This is a second example of the Conflict Economic Act, okay, all the elements under the Act, and then environmental quality acts, and then okay, last one is I said just now, SDG 17, okay, those legislation related to SDG 17. This okay, probably can be discussed in second sections. When we talk about implementation in the future, there are a lot more things to be done. Then okay, not only relying on the slides probably, all panels can give more or better ideas, views okay, on how to implement this in the future. I think okay, that's all. Thank you very much for the opportunities again. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Jadi. I have some highlight from your lecture today. The SDGs also, the land reform also have a strong connection with the SDGs, and then connected to the one of the target is about the environmental sustainability, yeah, Dr. Jadi. And when we're talking about further about the environmental sustainability, it's also for the bio conversations, and one of others is about the climate change itself. So one of one of the policy that should be taken by the government in order to sustain the environment, such as conduct some climate change action, bio conversation is in the policy of their land reform itself. Thank you very much. We'll give applause again for Dr. Jadi. Okay, students, ladies and gentlemen, we're going to have our third speaker. Here we have Dr. Christina Fixter, PhD, who will deliver her material about the criminalization of environmental harm doing with the theoretical perspective in the European Union. So, Dr. Christina, you have 20 minutes, same with another panelist, and the time is yours.
Thank you. Thank you for the floor. So thank you for the floor. My name is Christina Ficsor, and I am from Hungary, from the University of Debrecen, and I mostly teach legal theory at my university on legal reasoning. And now my topic and my research topic is in criminal law. I will talk about what's happening in the EU now, and especially in Hungary, about, and I will ask the question whether criminal law is an effective tool for fighting against climate change and environmental pollution. Thank you. First, I would like to speak about, just for a short time, about criminal, European criminal law, about the principles of European criminal law, and I will go back to the 18th century to Charles Louis he was a French lawyer and political philosopher in the 18th century from the age of enlightenment, and he contributed to the development of how we think about the grounds of state power in modern European states. His theory of the separation of powers is still influential and included by modern constitutions. And he, in his book, The Spirit of Laws, he wrote a lot about criminal law and principles of criminal law. And he said in this book that political liberty consists in security, or at least in the opinion that we enjoy security. This security is never more dangerously attacked than in public or private occupations. It is therefore on the goodness of criminal laws that liberty is the subject principle depends. I think that from this we can conclude that criminal law mostly reflects the moral relationship between the state and the individual, and it establishes the legitimate grounds or limits of taking or constraining individual liberty by the state. So I think that criminal law is a moral thing. It's about moral conviction of some actions and conduct of people. So what do we mean by goodness of criminal law in European criminal law? The goodness, I think, depends on substantive and formal demands that criminal law must achieve. The substantive demands are about respecting human rights and individual autonomy. The ultimate principle in criminal law that criminal law must be used as a last resort, as we know, and the principle of humanity. This means that the criminal offenders are human beings and respect rights of them too. And there are the formal demands of criminal law, which are mostly the principles of legality. We know that minimum clemency principle means that criminal offenses can only be defined by law, by the authorized legislator, and the norms of criminal law must be very clear and precisely defined, just to provide for people to foresee the consequences of their actions in criminal law. These are the more important principles of European criminal law, and I think we can attach the environmental problems in the EU. Next, I would like to show you some important European institutions who are most important decision makers in the EU. One of them is the Council of Europe. This is not an EU institution, we must know this. It was founded in 1949 and has 46 member states. And the goals and objectives of this institution goes beyond the EU, as you can see. The mission of this institution is to promote democracy and the protection of human rights and the rule of law. And among others, it sets standards to tackle the future challenges of climate change and the protection of the environment too. And under the aegis of this institution, we can see it established a Convention on the Protection of the Environment through Criminal Law in 1998. But, however, the Council of Europe has decided to replace this convention to a new one because it was evaluated that criminal law and criminalization of environmental harm is not effective enough. So we have to replace this convention with one and to define more precisely environmental crimes and to make protection of the environment more effective. And there are you can see on the slide on the right side, especially EU institutions, the Council of the European Union, the European Parliament, and the European Commission. They are the main decision makers of the European Union. they are negotiating and adopting legislative acts in those cases. And the Commission, the European Commission proposes and implements laws which are in accordance with the objectives and the principles of the EU treaties. So the European Union established a directive of 2008 per 99 EC. This is also on the protection of the environment through criminal law. And the EU has also decided to replace this directive because the European Union, the European Commission evaluated the situation of environmental criminal law, and it has also decided that criminal law is not effective, and recent criminalization and investigation and these things are not effective in the European Union as well. So now the Council of Europe and the European Commission started to negotiate, and by the end of this year they would like to make or establish the new convention and the new directive on the criminalization of environmental crimes. So these are the institutions of the EU, and not just the EU. And you can see that it seems that criminal law seems to be an important tool for the EU institutions to deal with climate change and environmental pollution and environmental crimes. It makes large-scale efforts to protect the environment and to fight against climate change, but it seems so that we have to be more precise, and we have to change the laws on this. I would like to show you some kind of principles or some directions or some conception of environmental criminal law, how we could use criminal law in fighting against climate change. In the earlier approaches in the EU, it was the conception that criminal law must be dependent of administrative environmental law, and now we are on the way to isolate criminal law from environmental administrative law. Both approaches have their disadvantages. When criminal law depends on administrative environmental law, it can be replaced in legislation, because criminal law has different approaches as administrative law, and when we isolate completely administrative law from criminal law, it has also disadvantages, because criminal law cannot deal with environmental crimes. It would be just also chaos in criminal law, because it would be more abstract. Criminal law can deal in abstract concepts, and the principles of legalism would not be effective in this kind of approach. But in the EU, now we would like to have these kind of approaches, mixed approaches, and we would like to think differently, and we would like to approach the criminal environmental crimes. On the slide you can see which kind of harm we would like to criminalize: abstract endangerment of environment, and concrete endangerment of environment, and serious environmental harm. These are the most important type of conduct that we would like to criminalize and be approached by criminal law. But on the next slide, I would like to speak about some Hungarian experiences. As we can see, the criminalization of Hungarian, in Hungary, the criminalization of environmental harm is discussed. But you can see on the side that there are a relatively low number of cases. And the most important and the most offenses that are perpetrated are offenses with, for example, like pollution of soil and water, illegal incineration of waste, illegal cutting forest. And as we can see in Hungary, these special types of perpetrators, there are special types of perpetrators that are connected with environmental harm, environmental crimes, and poverty, and low level of education sometimes plays a huge role. And criminal law is really not effective in this kind of, or against this kind of perpetrators. And nowadays I don't know because I had more slides, but the most important the most important thing now in my hometown in Debrecen, they are being built battery plants. And a lot of demonstrations were against battery plants, but the Hungarian government ignored these battery plants, and it seems that environmental criminal law is not effective in Hungary and in the EU as well, and we are trying to fight against them. The citizens trying to fight against these environmental harms and environmental crimes. For example, the demonstrations, but it seems so that the government not strengthened, but weakened the protection of the environment, unfortunately. So I think that if we don't change our minds on this, then criminal law cannot help. Yes. So thank you for the attention.
Okay, thank you very much for Dr. Christina Fischer for a very great discussion today. So we're talking about the effectiveness of a penal sanction or the criminal sanctions toward the environmental law, yeah, as one of the instrument to enforce the environmental law itself. Yeah, it's very same with Indonesian system, I think, Dr. Christina, that we have a regulation to combine the administrative aspect with the criminal aspect. So it's very interesting that we need to determine more about what kind of action that can be criminalized using the criminal or penal sanction. Thank you very much. Let's give applause again to Dr. Christina. Okay, so my students, ladies and gentlemen, we're going to have our fourth speaker. She is Phong Dung Nguyen, LLB LLM from Vietnam. Yeah, she will deliver her material about the environmental law and protection in Vietnam, challenges and opportunities. We have the same time, 20 minutes. Yeah, and okay, sure, yeah. So the floor is yours. Give applause to Mrs. Zung. The time is yours.
Selamat pagi, everyone. Sorry for my bad Indonesian. I'm really honored to be here. I think climate change has become a sexy topic nowadays, right? Because we human race, we depend on life on Earth. So no Earth, no human existence and other creatures as well. Actually in RMIT, even like we are university focused on finance and business, but you know what? Corporates are climate change contributor. because they are waste generator. And some people question me, why you teaching business law, private law, and climate change is somehow more related to public international law, right? Something more private. However, in my presentation today, I'm going to provide policy overview transitions in my home country, and I think that it's pretty the same story that we share with other members in ASEAN, like Indonesia. Yes. And through that, I would like to highlight recommendation in improving corporate responsibility. So as I already said, I would like to give you an overview of climate change, and thereafter I present Vietnamese policy and statutory regulations on climate change and environmental protection. And moving from that, I'm going to present challenges and also to close the presentation, implications for policy reform and improvement. Like Southeast Asia, all Southeast Asian countries, including Vietnam, are hit hardest by climate change. So my home country is a long coastline and we have diversified ecosystems and typically meet climate that includes temperate and tropical zones. By 2021, Vietnam is a populous country. Around over 98 million people right now. So the majority of them, a third of this population, resides in big cities like Hanoi and Ho Chi Minh City. So more people, and rapid urbanization that just quicken the climate change process in big city as well, and pollution to the environment. So in big cities, the problems with rapid urbanization, and in rural areas, suffering poverty and hardship regarding food security, because Vietnam is a country heavily rely on agriculture economy. And also, the agriculture sector, including livestock, crops, forestry, fisheries, are key contributors to the economy and accounting for 50.7% of the nation's economic growth. The statistics show in 2021. This is somehow the climate change situation in Vietnam. So through the last decade, we was ranked in third place according to the global risk climate change. One of the top 10 countries in the world suffering the most climate change impacts. So normally, especially the central part of Vietnam, this is a picture taken in the coastal central part of Vietnam, I think Quảng Bình or Quảng Trị. So the flood just disrupted, the farmers' crops, and the whole city and towns were flooded for days. Also, we recorded some climate disaster, natural disasters like Typhoon Nocturne 2011, Typhoon Haiyan 2013, Typhoon January, and other climate change impacts. And this also like domino effects, form the range of average temperature, and the heat were trapped in the atmosphere, changing other water patterns, and we experienced some kind of acute weather events. And this year, sadly, we experienced in El Nino and in Hanoi right now, it's really warm. It's really warm when people question each other when winter is coming. And this is also, the chart that I would like to show you, the average temperature that World Bank in Vietnam reported. And you can see that, especially in summertime, the temperature is really high. I remember just last year, the temperature in Hanoi, in the old quarter, right? They put the thermometer on the surface of the road, and the temperature is 45 Celsius degrees. Yeah, it's almost kind of, you can boil eggs. People even boil eggs on the street. And as I say, climate change adversely affect our food security. And just because we highly exposed and vulnerable to climatic events, and that just affects Vietnam's agriculture sector. This is like the report, the statistics, all the weather events reported, documented by our Ministry of Natural Resources and Environment. You can see that from the north, Vietnam is a kind of long country, so we have different kinds of weather in each region. So from north to the south, you can see that all the kind of severe weather events happen, and the two deltas that we cultivate paddy, the Red River Delta and the Mekong Delta River, are facing severe weather, climate change impacts like floods in the north, landslide erosion, and in the Mekong Delta, the sea level rise and salinity intrusion, which is like threatening our food security because Mekong River Delta is the highest producing paddy for the whole country and for exportation as well. So, Vietnamese government recognize the importance of protecting, safeguarding the environment and respond to climate change. So they have been actively engaged in the international community's response to climate change. And then you can see that throughout the years, Vietnam has become a member and participate in universal climate change and environmental protection treaties. So we have been a responsible member of UNFCCC, UN Framework on Climate Change, and also we acceded to Kyoto Protocol, participate in Paris Agreement, and recently we just updated our national determined contribution just to show our commitment, stronger commitment to climate change and environmental protection. So this is kind of some just an overview of all legislation. As you may know, that Vietnam is ruled by our Eastern Communist Party, and for all the laws and regulations to be formulated in Vietnam, we base on in the spirit of policy documents formulated by the Communist Party, and the party, with their cognizance of climate change response and the need for safeguarding environmental protection, they issue throughout the years from 2013 to recently 2021 all the kind of documents, policy documents, and guiding the formulation and establishment of regulations in Vietnam. And from the presentation of Professor Chris, we know that nowadays the international community recognizes the right to healthy environment. And it's not only restricted only to us as human beings, but it also expanded the international community developed this right, the right to healthy environment, to other I think objects or subjects like nature and future generations. And under Vietnamese constitution, the state recognized the right to a healthy environment of all Vietnamese citizens, and the state considers environmental protection is the obligation of the state and also all Vietnamese citizens as well. And this is the roadmap of all climate change and environmental protection policy and regulations. So we develop throughout the year. Vietnam is a civil law system like Indonesia. So through the practice, we kind of develop legal documents, and you can see that environmental protection is seen, the state considers is their responsibility and also obligation of all Vietnamese citizens, and they kind of issue specific law to protect, let's say, water resources, natural disaster, how to respond to maintain diverse biodiversity, and also preserve natural resources and the environment of the sea. And the key law, the key legislation is the law on environmental protection. And the former version is the law on environmental protection, enacted in 2014. But recently, we have reformed from practice, and then we issued the new law, the law on environmental protection, in 2020. And this is also when the law on environmental protection was released, and with the advance of other environmental protection like law on water resources, law on natural resources, we also have guiding documents as a share. Vietnam is a civil law country, so each step we take step by step. Right? Each year we have guiding legal documents, and the year on the spotlight here is 2022. That we have some kind of key documents like Decree 8, Decree 6, just guiding the law and environment, but with a focus on how we're going to curtail carbon emissions, which I'm going to present in detail in my guest lecture this afternoon, and also guiding how we're going to impose liabilities on corporates. And this is some kind of key contents in the law on environmental protection 2022. So when corporates, right, foreign investors, we know that foreign investors would like to make foreign investment in developing countries, right? We have natural resources, we have cheap human resources. However, right, Vietnam recognized that we cannot pursue economic development at any price. We cannot exchange environment for economic benefits. So that's why the government issued a new law, and they set out criteria, and let's say based on the features of investment project, and then some license and approval that you need to obtain. When I practiced as a lawyer before, so let's say a normal company, like consulting company, so the consequence that they're going to generate to the environment is minimal. But however, a Japanese company, let's say they specialize in engineering and produce hazardous waste. So for them, there will be more requirements, and they have to do intensive environmental impact assessment, and then show to the Ministry of Natural Resources and Environment for approval. And also under the new law on environmental protection 2022, we also impose liability on corporates, especially promote them to recycle and will the most like hardest material that we still struggling to recycle, plastic. And also the guiding document decree number 8 reflects the positive impacts of government regulation and also set out the roadmap, like the blue, like kind of the blue guidelines for corporates and also other individuals to kind of restrict the use of single-use items, non-biodegradable like plastic products like single-use plastic bag. And we also aim to pursue like circular economy, right? This is a little bit more to eco-economics, but circular economy, unlike traditional economy, right? We just consume and then we recharge, right? We discharge into the environment. But circular economy, it's just like a circle, right? We kind of consume, but all we reuse, right? The combustion of fossil fuels, and then we try to recycle and bring back the trash into the production, and that is the objectives of the Vietnamese government would like to promote in the near future. Actually, they implemented this decree in order to promote and encourage corporate to kind of recycle plastic. And this is somehow, these kind of documents somehow set out the timeline for us to reduce plastic, the use of plastic bag, and you can make some kind of details. Yeah. And throughout, I kind of show you that this is kind of the statistic that show that Vietnam improved the forest quality and also the forest coverage. And however, sorry, it's just we only have 4 minutes left, so I would like to focus on the challenges. So the challenges here is the climate change scenario. Right. We cannot avoid climate change. Like Professor Chris already said, we cannot avoid using fossil fuels. So climate change will happen. But how are we going to mitigate and adapt to climate change? And this is the scenario in Vietnam, and you can see that the less severe and the more severe. So somehow this is kind of challenges quite formidable for the Vietnamese government. And how are we going to cope with this? And it also affects our food security as well. Yeah. As I say, Vietnam has high population number. So raising population, right, means that observe in waste. So the waste management is a problem in mega cities like Hanoi and Ho Chi Minh City. However, our waste management depends on informal sector, and we also have like public company doing waste management, but the infrastructures are a bit underdeveloped, and we still lack technology and heavily rely on landfill, right? And we know that landfill, like the waste that is absorbed to land, degrading the land, and also like some plastic mismanaged in the ocean. We have 2 cases here. This is the incident sadly happened to us in the past. Hit by river pollution by Vedan. You know Vedan is a Taiwanese, right? They produce spices to make the taste better. However, unlike their products, the waste that the sewage that we discharge in the river is not like that. And we also experience in the next few years Formosa has become like somehow like become viral. last year, I think, last few years, it killed massive fish. For 4 years, people wouldn't like to swim in the sea or eat the fish from Hatay province. And the toxins that Formosa failed to address and directly attract into the marine ocean just kill the fish, and it also pose long-term impacts, like fishermen, they lost their job, and local communities can no longer maintain their fishery as a key industry. So recommendations. So in the next few years, we focus on reduced carbon emission, and we also promote, legal action, better protection for local communities sustaining severe impacts due to corporate violation of environment. And with some kind of focus on waste management, so we try to have more alternatives instead of landfill, but incineration and more hygienic methods. And air pollution is also another concern happening right now in Hanoi recently. And also we need to improve air quality, land environment with Professor Zabi, because we know that land is really important, like the natural resources. And talking about green finance, we kind of also promote green investment that maybe provide incentives, tax incentives for projects with a focus on environmental protection and renewable energy. Solar and wind farms have been developed recently through the coastal area of Vietnam, in the southern coastal area of Vietnam, and also in the long term for sustainable development, pursue circular economy. And I think that together we can go further. And the situation in Vietnam is not the only story happening in Vietnam. But I think other Southeast Asian countries as well. And I hope that we can build a better climate change governance to, safeguard the healthy environment for all our citizens. Thank you.
Such a comprehensive presentation for Mrs. Zhu from Vietnam. Also, we have several notes from her presentation. Yeah, we already discussed about it, that when we're talking about the regulation of environmental protection, is already quite perfect enough. But the challenges is about the implementation and also the legal enforcement itself. I take a note for several good aspects here that the governments of Vietnam already take some action, such as also your suggestion to conduct waste management better, not only just by landfill method, because the methane is one of the sources of the global warming itself, and one of others that already done is about the regulation, more regulation about the foreign investment that the investors should conduct hazardous permit, then they also have hazardous management system, and also have a strict method to waste management for foreign investment. Yeah, this is also the new aspect about the adoption of circular economic approach for the waste management system, and also recover the forest condition and others kind of challenge to be addressed too. Thank you very much. Let's give applause again for Mrs. Zoom. Okay. So ladies and gentlemen, my beloved students, we will have our last speaker. She is Ibu Siti Ruhama Mardutila SHM. Let's connect with her using Zoom meeting. Hello, Bu Titi. How are you there?
Hello. Yeah. Can you hear me?
It's perfectly.
Okay.
Yeah. Is it already winter there?
Yeah, it's getting dark because it's still it's 5 a.m. but it's still dark. Yeah.
Okay. But in Indonesia, it's still hot, Miss Titi.
Yeah.
Okay, so
Okay.
Miss Titi will deliver her materials about what Indonesia can learn from climate change litigation in the EU, European Union. It's also like part of your dissertation, I think, about the climate change litigation, yeah? So, Miss Titi, you have 20 minutes, so the screen is yours. You can start your dissertation. Please give a applause to Miss Titi.
Thank you very much. But first of all, can I share my screen now? Well. Okay, thank you very much, Miss Moderator. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. The Honorable Dean of the Faculty of Law, University of Islam Indonesia, together with the Vice Deans of the Faculty of Law, the Honorable the Head of the Undergraduate Program, together with the Secretary of the Undergraduate Program, and the Honorable of all the invited speakers. It's an amazing thing that you are internationals, but you can present from Indonesia as a person, while me as an Indonesia, I have to present from the overseas. That we can realize now that our world becoming more and more borderless, and also my lovely students, my blessed students. I very miss you all, and thank you for having me, and thank you for inviting me. Well, I would like to discuss with all of you regarding the climate change litigation against the government, and we want to focus more about what Indonesia can learn from the European Union. Of course, this is part of my dissertation, I think, because it's the easy way to present to all of you them. The topic is also about the climate change litigation. I also get inspired a little bit about the comparative aspect of my dissertation about Indonesia, but I also use a little bit comparative aspect to the European Union. Okay, this is my table of content. It's just give you a general overview about what I'm going to talk in the upcoming 20 minutes. The first is about what's climate litigation definition, because maybe some of you is just heard now about climate litigation, and the definition is also a little bit tricky. And the second, I would like to address the main differences between climate litigation in Indonesia and European Union. I intend to put the focus at the very beginning because I don't want you to lose my main idea through my presentations. And the third is about why climate litigation becomes a global phenomenon. And the fourth is about climate cases in Indonesia. We will get more focus and discuss further about climate litigation in Indonesia, what kind of the cases, what are the example, we can go deeper in this section. And in the fifth, I would like to address or discuss to you about climate litigation in the EU. Actually, there are a lot because every jurisdiction now has their own climate litigation. But in the EU, I just want to highlight the biggest three climate litigation. The first is Urgenda from the Netherlands, where I live now. And the second is Neubauer, comes from Germany. And the third is Friends of Irish Environment. Of course, it comes from Ireland. And the sixth, we would like to make some conclusion what we can learn as a nation from the climate litigation practices in the European Union and try to make our climate litigation in the future more impactful. And the last, of course, because it's still hot, the conference of the parties in Dubai just 2 days ago end up. So we have to remind ourselves and, of course, our government about our commitment to the global community regarding our nationally determined contribution to reduce the emission or greenhouse gas emission. Okay, I would like to start from the very beginning. It's about the definition of climate litigations. It's about the litigation. It's the simple way to explain to you by the picture that we have the climate issue, as the speaker from the Vietnam already present to you about the effect of the climate change in her country, but actually the impact of the climate change can feel globally. And there is a citizen, there is a group of people or the NGO, they put a concern about the issue, and instead of protest to the government directly or proposing the claim to the government directly, they choose to go to the court to take the litigation action and ask the court to order the government to adjust or to change their policy to be more sustainable or to be more adaptive with the climate change. I mean, is this the phenomena because why the citizen choose court rather than directly go to the government? But this is that we call it as the litigation. This is the picture. I think I don't know how to explain in a more easier way for you. And this is the theoretical definition about the climate litigation, but I believe for you the picture can tell more rather than the words, right? And this is about the conceptualizing of what kind of litigation that we can call as the climate litigation. Is it have to mention litigation, climate change as the central issue, or is not necessarily mention climate change as the central issue, but it can be ordinary environmental law litigation or public interest litigation, but have impact to the climate change. And I love to refer from the conceptual of the climate litigation built by Peel and Osowski in 2015. They mentioned that climate litigation is not only litigation that mentioning climate change as the central issue, but it could be also environmental litigation, even though they didn't mention specifically or precisely about climate change. But if the litigation have the impact to the climate effort, so it could be also called as the climate litigations. Honestly, right now, Indonesia in this country, we don't have climate litigation that put climate change as the central issue, but we have climate litigation in the third or fourth layer. That is climate litigation as the climate change as the motivation to sue the government, and also there is maybe the plaintiff didn't care anymore about the climate change, but they didn't realize that the claim to the court is also gave an impact to the climate change. So this is I love from the conceptualizing from Peel and Osowski that what happened in Indonesia can also be called as climate change litigations. And this is I put the difference between Indonesia and EU in the very beginning. What is the similar from both of the regions and what is the difference from both of regions? The similar thing, climate litigation in Indonesia and in the EU can be included as the human rights-based litigation. Human rights-based litigation because both of the region, the climate litigation, put the claim based on the rights, based on the constitutional rights. As in Indonesia, we have Jakarta Air Pollution climate litigation, or maybe we more understand with the terminology of the citizen lawsuits. Or in the 2015, we also have the litigation against the government in the case of the forest fire, in the case of the smoke haze pollution that is caused by the forest fires. Both of the cases in Indonesia also put the right of the healthy environment that is already regulated in our constitution in the Article 28 of our constitution. Well, in the EU, let's say we take the Urgenda case, they also put the claim based on the Dutch constitutions and also put the claim based on the European Convention of Human Rights regarding the right of life. So in this level, we have the same similar thing that our climate litigation put the human rights aspect as the basis. And the second of the similarity between Indonesia and the EU, the climate change litigation, especially those against the government, claiming the government unlawful for its certain legal policies. But the difference between Indonesia and the EU, in the EU they focus more about the government's policy regarding the setting up the target of the emission reduction. But in Indonesia, the case is different because again we don't have the climate litigation that put climate change in the central issue, but we more about a specific issue regarding air pollution in Jakarta or regarding the forest fires. And the main difference between Indonesia and the EU, that Indonesia climate change is not a central issue, as I mentioned before. It put as one of the motivation or rather than a central issue. But in the EU, most of the climate litigation and the three big cases that I mentioned before, all of them put climate change as the central issue. They try to compel the government policy to set up more ambitious emission reduction target. And then I will discuss later about this. And what is make Indonesian special, of course, in Indonesia, both of the plaintiff and also the judge rulings, they mention specifically what the government agency that has done unlawful action, like say they mentioned the President of Indonesia, the Ministry of Environment, the Ministry of Interior, the Minister of the Healthy, or even the Governor of Jakarta as the liable governmental agency in this case. And the court orders specifically by mentioning those agency what action that you should take in order to make your policy more sustainable or more environmental friendly. But in the AU, the climate litigation, they didn't mention government agencies specifically, but they just mention in state as a unity working for the climate change. So they just mentioned the state of the Netherlands, the state of the Germany, but they didn't precisely point out what the government agency should do something. This is important because in European and also in the Western country, in the US as well, it raises another issue regarding the separation of power. Whether is it justified or not, if the court ordering government in that way. I mean, so this is the interesting way. And this is also why the climate litigation become a global phenomenon. I will not spend a lot of time here, but at least you know about it has happened gradually since 1980. And this is, as you mentioned, it's becoming more and more increased. And of course, I inspired all as well from Mr. Chris' explanation that in the US, sue each other is like a sport, and it is also proven that the number of climate litigation in the North America is the highest. Well, you can go to this website if you want to know more about climate litigation in each jurisdiction. It is a good sources because you can also find out a lot of climate litigation in every jurisdiction, and you can also find out the verdict or the ruling in its original language. But today we have Google Translate, and I think it's not a big issue. Then this is the focus. Then what makes Indonesian climate litigation different from climate litigation, especially from those in the EU? I have explained it in the beginning, but I want to share to you about climate litigation in Indonesia that is against the government. We have some, but in this case, I just want to focus the number 3 and number 4 because this is a successful climate litigation. Because at the end, the court ruled in favor with the plaintiffs and ordering the government to adjust their policy. We have the Ari Rompas versus the Indonesia in 2016. This is the case of the forest fires that the citizens or residents of the Palangkaraya compel the government policy regarding their effort or their legal policy in tackling the smoke gas pollution, and also compelling their policy in land and peatland and forest management. They try to ask the court to order the government to improve their policy regarding forest fire prevention and also the smoke gas pollution prevention. So at the end, the court ruled in favor with the plaintiff, but the government take an appeal until the Supreme Court. All of the court ruled consistently in favor with the plaintiff, but unfortunately, at the end, they take some court review, or we call it in Indonesia as peninjauan kembali, and then the court of the Supreme Court then eventually in favor with the government in this case. And we also have a case of the Jakarta pollution brought by Melanie Subono versus the Indonesian government. It's happened in 2019. Maybe it's just happening not so far. That's Jakarta air pollution becoming an issue again. But actually, we already have the climate litigation against the government regarding this issue in 2019. And again, the court ruled in favor with the plaintiffs and ordering the government to adjust their policy to be more advanced in this case. From both cases, we know that they didn't mention specifically climate change as the central issue. There is another environmental issue outside of the climate change. But if the court ruled in favor with the plaintiff and the government in cooperation with the court, by accommodating the ruling of the court and change their policy, I think it's mean a lot for the climate change mitigation adaptation, right? It means a lot. It's impactful for our mitigation adaptation effort. So this is, I agree with the layer, even though we didn't mention climate change as the central issue, but it have a huge relation with the climate change. And this is that I mentioned before, the three cases of climate litigation in the EU. The first is from the Netherlands. Urgenda versus the Netherlands is about revising climate policy by requiring more ambitious greenhouse gas emission reduction target. And the Urgenda is environmental NGO. While in Germany, we have Neubauer versus the Kingdom of the Germany. Neubauer is the name of the person, is the group of youth shoot against the government and arguing the constitutionality aspect of the emission reduction target that contained in the Federal Climate Change Act 2019. And the third, we have the Friend of the Irish Environment from Ireland. This case is about, in Indonesia, we call it as the judicial review. That's the government set a national mitigation plan, but they considered that national mitigation plan set by the government is insufficient or not in line with the Climate Change Act that's already set up by the legislation. So this is, we would like to discuss from the first is about the Urgenda versus the Netherlands. It's just like at the beginning, the government, the Dutch government set the target of the emission reduction 17% by 2020. And the group of the people called as Urgenda consider that this target, this policy, insufficient to protect the Dutch people and to protect the future generation. Then they went to the court and asked the court to order the government to improve their target in emission reduction. And at the end, the court agreed with the plaintiff and ordered the government to set up the emission reduction target at least 25% by 2020. And of course, the government has their own contra argument, but I would like to discuss this part because it's get to long discussion. This is what I mean as climate change as a central issue. And the second case is Neubauer versus the German. It's about the constitutional court. In Indonesia, we also have constitutional court, but we didn't have claims to the constitutional court regarding the climate change. But in Germany, there is a Federal Climate Change Act that set up the target of the emission reduction 55% by 2030, and the group of youth led by Neubauer consider that this target 55% GHG emission reduction by 2030 is insufficient to protect the future generation, and it is unfair for the future generation, because by setting this target, um, the Germany put the more burden to the future generation to reduce more compared to the recent generation, while the recent generation still have a lot of financial sources to do so, while the future generation, they may have less financial sources to do so. So this is about the intergeneration equity regarding the climate actions. And the court eventually ruled in favor with the plaintiff and say that the government should improve their target to be at least 65% by 2030 and 88% by 2040. And this is the last case from the European Union, Friends of the Irish Environment versus the Ireland. The case is about challenging the government policy in National Mitigation Plan to the Climate Law Act. Because
Sorry, Ms. Titi, we have 2 more minutes.
Okay. Okay, actually, this is the same cases. They try to get more advanced climate policy, and they just to go to the court and asking the court to order the government to improve their policy. Well, what Indonesian can learn in this case, there's 4 things. The first is strategic climate litigation. Maybe for the future climate litigation, we consider to put the climate change as the central issue rather than to a peripheral issue, or we don't even consider at all about the climate change. Maybe we can try climate change as the central issue. Why? Because we will get more comprehensive policy change in this case. We didn't only talk about the forest fire, we didn't talk about the air pollution, we didn't talk about the coal mining operations, but when we just shoot the government or criticize the government from the policy of the climate change, I think all of the issue about the environment can go together with the climate. So this is what we can learn from the European Union. And we also need to consider to put national determined contribution in our claim for the future climate litigation, if there is. But unfortunately, we don't have climate change aid recently. It's also proposed by a lot of environmental law scholars that Indonesia should think about climate change aid, because we can review, or we can propose the judicial review to the constitutional law, but with the basis of the international commitment, because what Indonesia now has is only international commitment to the global community, nationally determined contribution, but not as the aid. So this is important. And the last is we need to educate, or we need to more sounding to the people that climate change is not an issue for just for the elites. It is a social issue. The impact is very tangible. But I think in Indonesia, climate change is still the elite issue. It's not social issue. So we need to start teaching or educating people in Indonesia that climate change is not only issue for elite, but it's a social issue. And this is okay. And well, we have to remind that we have a commitment to the global community, that nationally determined contribution of Indonesia, that we commit to reduce our emission 39% by 2030 with our own self-effort, but with the international support, we target more, 43% emission reduction target. Why nationally determined contribution is important? Because it's to ensure that every state has a proportional contribution to prevent the increase of the Earth's temperature to less than 1.5 degrees. I think that's all from me. We can discuss further about this. Thank you very much, and wassalamualaikum warahmatullahi wabarakatuh.
Okay, thank you, Ms. Titi. What an excellent explanation to compare between about the climate change litigation between Indonesia and also the AU countries. I take a note several main aspect that you already delivered, that even Indonesia already have 4 citizen lawsuits, but we still use the climate change as the motive, not as the main main topic of the claim or the lawsuit itself. That's one of the difference between Indonesia and NU, and also about the defendant position. We need to mention the exact governmental agencies as defendants, where the AU, which they just mentioned the state as the defendant. And also we take a note some of your suggestion that first, the climate change should be used as the main reason to write a lawsuit towards the governments, and then using the NDC as the basic of the lawsuit. It's very excellent. And then the number 3, to establish the Climate Change Act. We do not have those one, Ms. Titi, right? And the last one is to mainstreaming that the climate change is become the common issue. So again, please give a big applause for our 5 panelists today. So my beloved students and ladies and gentlemen, now we come to the Q&A or discussion session. I will give you first attempt to give a Q&A or questions for our panelists. Please first mention your name, your institution maybe, and also mention for whom your question addressed to. So I'll give the first attempt for 3 students. Please raise your hand, 3 students. Please raise your hand. Okay, Miran first. Okay. Number 1, 2, one more. Ladies, maybe. One more. Okay. So start from Miran and then go to the right side.
Thank you, ma'am, for giving me opportunity to ask question. So my name is Miran, and I'm studying in here in UII in Bachelor of Law. So my question is, like, anyone willing to answer it? So it's a journal. Like, I'm wondering about the environmental laws. Sometimes we see the environmental laws is previous president of US stated that, like, there is no environmental law. If sometimes we see, I think it's true, like he stated that we cannot make missile or bomb, missile or tank as electric missile or electric tanks. So as we see, like the countries such as Russia, what Russia is doing in Ukraine, what US itself did in Afghanistan, and what other countries like Israel is doing in Palestine, and some of them like Canada or European countries doing these things in software, like taking the minerals and violating the environmental laws. So why do the developed countries, often seen as leader of the environmental protection, fail to uphold the standard of developing countries? For instance, like the Barrick Gold Company, which is taking the gold and everywhere in the world, violating the environmental laws, including in Pakistan as well. So what prevented these nations from effectively protect the environment in less developing regions?
Thank you very much. So you address your question to all the panelists about how they can prevent the environmental damage from many kind of activities such as armed conflict and also many others, like more modern sorts of environmental damage, I think. So thank you very much, Miran. We'll move to another students, please. Mention your name, your class.
Thank you very much. My name is Aditya Krishnamurti. Question for Ms. Pong Tung Nguyen. Yesterday, I researched waste management in universities in Yogyakarta. Universities are one of the biggest contributor into waste in Yogyakarta. For example, the landfill speak bahasa Piungan in overload and close cause health problem for the community around the landfill. To question how is the protection of the people affected by health problem due to poor waste management in Vietnam, and to how is waste management regulated in Vietnam. Thank you very much.
Okay, so the first about how we protect the health of the people that are affected by bad waste management system done by the governments and your regulation itself. Thank you very much. Next students, please.
Hello, good afternoon all. My name is Muhammad David Hanif. I am from Faculty of Law, Universitas Islam Indonesia. As we know, in Indonesia there are many land disputes, especially about customary rights. So my question to Professor Dr. Jaidi Zaidi bin Hasim, my question is, how Malaysia resolve land dispute between indigenous people and the government or others like private corporate, and how law in Malaysia protect indigenous people and customary right there? Thank you.
Okay, thank you very much, Dr. Zaidi. It's about the land dispute, between the indigenous people versus governments and also the corporation. I think we will start with the Mrs. Zung first to address two questions, the general question and the specific question, and then go to Dr. Jadi and then continue with another panelist. So please.
I think the student, sorry, I'm really bad at pronouncing your name. So the student from Pakistan, he raised very interesting point, and I think it's also the problem of international law as well. So there's no enforcement. I have to say very weak enforcement in international law. And you know that states, right, when we study public international law. So states are the main actors participating in all transactions or relationships, right, under international law. And with its power and one special feature that other subjects don't have, state sovereignty. No one could stand above that state. So if state fail, right, its obligation, no one can enforce anything. So we kind of still have controversial debates or over state responsibility to environment. And you realize that there's, to some extent, we have environmental regulations, but we do not have environmental law. Environmental standards like human rights standards are kind of contemporarily developed by international communities. So it somehow undermines or dilute the state sovereignty, right? Because like we recognize that climate change and environmental law protection nowadays become new security crisis, right? New security threat. So it's not only state, right, to control and manage what happened inside their territories, but also what happened in their territory, right? Climate change contribute to the global climate change, raise global average temperature, affect global community as well. I think only UNFCCC, it's just a political agreement. I think Kyoto Protocol, right, only states in Annex 1, right, developed countries have obligations. But non-Annex 1, non-Annex countries, developing countries like my home country, Vietnam, we do not have obligations. And Paris Agreement is the first universal, I think, over 193 signatures and participants. The first universal binding environmental, international environmental law agreement that address on climate change. However, you know, to some countries, right? With my all due respect to the government of USA, Professor Chris, but during Trump, right, the former president of USA, Trump called climate change is just a hoax, Nobody believes that, right? He just say that, no, it's a horse. And he went really ordinary about climate change in order to cast more votes from, more, less liberal, right? More Republican states with a focus on, combustion of fossil fuels. And he withdrew, like USA, from Paris Agreement. So it's still kind of like controversial nowadays. And I think the majority of states haven't completed their objectives. And even like we kind of pursue, climate change objectives that we already show commitment under national determined contributions. Climate change still happen. It's really difficult to control within the limits, like within 1.5 Celsius degree, as set out in the Paris Agreement, yeah? I don't know yet. I think this is the formidable challenge. Climate change to me is a formidable challenge. And what we're going to do now that we try to combine different methods, including, let's say, green financing nowadays, that they place more particular emphasis on investment in projects for environmental protection. And also, one of my topic today, carbon trading and development of carbon markets. Yeah, and with the development of renewable energy. But I believe that positively, hopefully in the future, with combination of all methods, we can maintain the temperature. We cannot avoid climate change because it's almost too late. It's almost too late. And even right now, we still rely on, the use of fossil fuels as shown from the statistic and diagram by Professor Chris. So I'm not sure yet, but hopefully the answer will depend on our future actions. Yeah. Yes, for your second question about the waste management in Vietnam, yeah, is a challenge to our government. According to a research by Jambert, I think that you all familiar with that research. In 2015, he carried out a research on mismanaged plastic in marine oceans environment. And it showed that Vietnam is, my home country was in top 10 for mismanaging, effectively waste, especially plastic waste. The kind of the main, waste management still landfill. And as show that we like landfill, and sometimes, the landfills are not really hygienic and not in, in the best hygiene condition. There's sometimes on the news that I read that the local communities living close to the landfill were under, the severe influence of the landfill impacts. Because they just bury, right? They just bury all the trash in the land, in that area. And then, some kind of the liquid leaked from the trash, right? It's smelly and it's also absorbed into the land. That's kind of raised concern about disease as well. And then we have some kind of like cancer villages. They have that kind of cancer villages that have some kind of chronic disease due to the trash. And we kind of like our government is planning to move from landfill to incineration, and especially use the trash to like waste to energy, right? Burn the trash to produce energy like electricity that we to provide more households, especially in the north. But to build factories or plants to treat trash requires a lot of money. Vietnam is still a developing country. We've got to become middle income recently, and we need more capital from developed country, and especially more important technologies, not only money but also technology. And for some kind of projects, I know that have been Kickstart has been launched, But seeing, this is also, another issue in the management as well. So for a project to be launched, the authority in charge have to prepare some kind of a financial plan, right? A financial plan, and then show to the state. And then from that, with the central state government approval, the money could be distributed through the state budget from the central to the local. And sometimes, the problem with the site clearance as well, the land use rights and how we going to compensate for people in that area in order to take more the land area to construct factories. It will take years, and the foreign currency exchange may increase. So that's why it may go beyond, right, what they had projected beforehand. So that kind of may cause, I have to say, maybe sometime like a barrier, to the finance distribution to have that, project completed. And but I think that the government right now is progressing in reforming the kind of the financial distribution from center to the local authority. It maybe to the more decentralized orientation and less bureaucratic, to reduce unnecessary procedures. As I say, it's less the time speak. Hopefully, my home country, with the support from the regional and international community, so we can effectively reduce the waste. And let's say what we have done, a good example with the forest cover and the forest quality. Yeah, thank you.
Okay. Thank you very much.
Okay. Thank you very much, Brother Muhammad, for asking good questions. Despite of, I know that, to a certain extent, probably your questions so not related to the topics being discussed today. Talking about probably native customary rights of the peoples. But yet, I think, to a certain extent as well, it can be considered related, as SDG 10, for example, try to reduce inequalities among the peoples, right? I try to answer it very brief. Number one, you must understand the differences between indigenous peoples and native. Some people confuse, believe that native probably indigenous. For example, in Malaysia, we talk about orang asli. Those lands that belongs to orang asli actually without title. Without title, in the context of Malaysian's torrent system, you do not have protections. It already being emphasized by many cases in Malaysia. For example, Siddiq versus the government of Perak. Whereas the peoples who having no title over the lands, having no protections under common law as well as equity. But then as we believe the progress of SDG then, to certain extent probably court then try to reduce inequalities among the peoples. Try to accept to a certain extent probably the rights of the communities, native people. That's why in the recent case, for example, in Tagung Sagi, the court not to say saying accepting, recognizing the right of the native peoples, but then try to compensate certain areas where the rights being conflicted. All right, that's with regard to those who having no title over the lands, having no title, no protections under common law, under the law as well as equity. But then with regard to disputes among native, those having title over the lands, there are many things, many protections given to them. For example, if you cannot go, for example, in the ordinary court, they do have what we call native courts. When we talk about land matters, disputes among those private parties, for example, who really want to take over the lands of these people, they are fighting over this matter in the native courts. And of course, by the name, it will try to protect, okay, the rights of the native people. That's why, okay, the governments of Malaysia, for example, come up with slides creating, okay, something, okay, more creative in nature. Instead of giving the land, for example, okay, to individual native person, they give it in terms of community. That's why in Sabah, for example, we have native communal rights. Okay, we're talking about numbers of big lands belongs to the community of native people of Sabah. Then, okay, having regards to this particular title, the rights of these people then, okay, be more protected. So it depends on what kind of disputes then, okay, being argued here. If, let's say, talking about those lands with title, without title, then, okay, different perspective need to be approached. I think, okay, that's probably can answer your question. Thank you very much.
Okay, thank you very much. So please address to answer the question from our students who asking about how we can conduct some preventive action by the government to toward the further environmental damage and also to prevent the climate change itself. Yeah.
Is it working? Yes. You know, I'm from Hungary, from Europe. And, you know, the European Union is a special international organization. There are countries, the members of it have different cultures, different political systems. But I can tell you an example of Hungary. For example, you know, the European Union have a very strict or determines very strict rules for their member states, and there are, of course, environmental laws and these obligations. We have the obligation to achieve these goals, what the EU determines for us. But sometimes when it is not in the country's interest or the government's interest, the government fights for its own sovereignty and tries to determine its own rules for example, now in the against the climate change or something. But my experience in my country is that we try to formally, we try to implement the rules and the principles of European environmental law, but when it is not in the governmental interest, then we fight against it. And people try to demonstrate against these, things that government has some companies which have serious results on the environment. And now our government changed our environmental law, and it says that you can escape the responsibility of taking the responsibility of overstepping the emission limits by contracting, by signing a contract. If you take the responsibility of, for example, to recover what you have done for the environment, that you can sign a contract that I will recover, I will do anything to recover the damages what I have done to the environment, then you can do what you want. So you can overstep the emissions and everything, but you have to recover it later. So I think this is a very it's problematic, I think, because who will control these contracts? But of course, we have obligations. The EU determines these obligations, but sometimes we fight against these obligations. That is what I can tell you now. Thank you. Thank you.
Thank you. First, to address, I think it's all about an enforceability issue in international law. Even you talked about in a international armed conflict, there's a war crime, A2B4, that does address intentional environmental damage, but then you get into the mens rea problem of, as discussed by Christina about how criminal law fails when it comes to the environment. And again, it is an issue even with, you mentioned developed versus developing economies, emerging versus developed economies. And, I think it's, there's always the issue of justice, whether it seems like the countries that are most harmed by, like Vietnam, most harmed by climate change are the least culpable for the climate change. And that's a hard issue to be addressed because, we can't say we'll give Pakistan 50 years to pollute just to catch up with our economy, because again, the science we're already there, as Dr. Nguyen said. So, yeah, I think there's an environmental justice component, and the other thing to address is, God forbid Donald Trump is elected again. That's where the judicial backstop, so to speak, where climate enforcement isn't based on who's in charge at the moment. There is an independent judiciary that can act as a backstop against that. I hope I addressed your question. Thank you very much.
Thank you very much, Pak Chris. Ms. Titi, are you still there? Please also give your answer for Miran's question. Ms. Titi?
Yeah, I'm still here. Okay, I would like to address the Miran questions about the equality between developed countries and developing countries in this context. Well, I think the climate issue is a global issue. Every state is mandated to combat the climate issue in its national level, and I think there is a principles there is a principle in environmental law, international environmental law, about the principle of common but different responsibility. I think it's principle applied in the context of the responsibility between developed and developing countries, because we know that we have our own NDC, National Determined Contribution, is of course different between Indonesia as a developing country and the European or Western countries, which are developing countries, developed countries. And also every country has to reduce the use of the fossil fuel, the use of the coal as the energy sources. But for Indonesia, the time frame to achieve net zero energy is longer than compared to the Western country or developed countries. So I think in climate change, in tackling the climate change, I think it's fair enough for us between developing and developed countries, because they contribute to tackle climate issue according to their ability, to their sources, and also to according to their economic abilities to do so. So maybe that's all my answer about the Miran question, and I hope I address your answer, your question well.
Okay, thank you, Ms. Titi. So please give applause to all the students and all the panelists. Okay, everyone, it's already 12 sharp. I think it's also time for you to take a rest, practice praying, zuhur, and also take lunch, have lunch, yeah. So, and also it's already the end of our session in this International Student Colloquium 2023. Again, I'll ask you to give a very huge applause to our all 5 panelists. Yeah, thank you again for all speakers, and thank you for all students who attend our conference today. Thank you for all speakers. You already enlightened us about the what we call it our topic today, climate change and the rule of law issue. Hopefully our students also can take a part of this issue. Yeah, one of which they can write their undergraduate thesis about the climate change issue. Hopefully, yeah. And I will end this session today by saying Alhamdulillahirabbil alamin. So let me close this session. Thank you everyone. Thank you all the panelists. Thank you all students, and congratulations to all the committee for having our hosting this agenda today. Thank you very much. I will end this session by Assalamualaikum warahmatullahi wabarakatuh. Thank you everyone.
Okay, so maybe we can take a photo together after this, but before of that, there are 70% from our head of law faculty, Mr. Dodik Setiawan, to the panels, and please come forward in front of the stage, maybe. So, Mr. Dodik, please. Okay, maybe also for the students after this, we can take a photo, if you mind. Okay, give applause. Thank you very much for all the students for your time to attend this event. Okay, give applause. And maybe if the panels is willing to take a picture with the students, please come forward. Okay, so while we're going to take a photo, I'm as a master ceremony. Well, thanks to all the participants. And lastly, I would like to say Assalamualaikum warahmatullahi wabarakatuh.